And I think I was giving us a transcription, which I can never figure out how to turn off, but problem for later. Anyways, I will go ahead and turn it over to Professor Sandberg. So thank you so much for joining us.
Thank you very much for the invitation. It's an absolute pleasure to be with you, albeit virtually, from a very wet South Wales. Right, I'm going to try and share the screen, and then we'll begin. So hopefully this will work.
Yes, I can see your screen reflected.
Excellent. Now. And hopefully now you can see the PowerPoint slides.
Yes. Is everybody else seeing this as well? Just before? Okay, perfect.
Excellent, fantastic. Well, thank you very much indeed for the invitation. It's an absolute delight to be with you. And it's quite a tricky, audacious title to this seminar that I've given. Why the history of English law is not taught. And as everyone on this call will probably be aware, this is a play on two prestigious and undoubtedly superior talks given in person in Cambridge. Right, let me just see if I can. Right, there we go. Given in Cambridge over the years, two inaugural lectures by Maitland and by Sir John Baker. And basically, sorry, I can hear myself echoing.
Yes, I'm sorry. Would everyone mind turning off their microphones? I think somebody has a bit of feedback coming through.
Fantastic. I mean, it's bad enough you've got to listen to me. I don't want to listen to myself. So yes, as I was saying, the title is cheekily adopted from these two inaugural lecturers. Basically, because I thought this is the nearest I'm ever going to get to a Cambridge inaugural lecture. So I will cheekily nick the title. And also because this webinar and indeed the book on subversive legal history does a similar thing to the inaugural lectures on this slide, in that it looks at and explores the state of play of legal history. And there's a sense of regretfulness there, but also a sense of how to try to make legal history even more dominant than it currently is. And indeed, the difference between my title and the titles by Maitland and by Baker is that their titles were very much about the writing and the research of the history of English law, whereas mine is focused on teaching. And I'm also aware, of course, that it's an audacious title because the history of English law is taught. It's not the case that it's not taught at all. In some places, including, of course, the place which is hosting this talk, it is taught a great deal. But the point I'm trying to make here, and the point which I look at in the book, is that generally speaking, yes, there are exceptions, but generally speaking, history, legal history, is not at the beating heart of the law school curriculum in England and Wales. It's not a compulsory part of legal education. It's quite possible and quite likely that many undergraduates studying law will never really come across much, if any, historical study. And the book, and indeed tonight's talk, is about why that is a bad thing. And of course, there's all sorts of reasons why legal history is important and why it is a fascinating area of study. But I'm trying to argue not just that legal history is desirable in terms of undergraduate law teaching. The book argues that legal history is necessary. It's a necessary corrective to what else occurs on the undergraduate curriculum. Because the basic argument, and in many ways, what I'm going to say over the next however many minutes, is just this theme constantly repeated. So my basic theme here, and the basic theme of the book, is that the nature and purpose of legal history is often misunderstood, particularly by those who are not legal historians. I'm aware that, like Maitland and like Baker, I am preaching to the converted here, and really the book isn't for you. The book is for people who don't already value legal history. But my basic point is that legal history is commonly misunderstood because lawyers conventionally use history to stabilize the law. They look back at previous precedents in order to stabilize and cement their understanding of what the current law is, either by showing that the current law has built upon these previous foundations, or to present the typical story which we find in textbooks and lectures up and down the land of, look how bad the law used to be and how gradually over time it got better and better. So that's the conventional use of legal history and history in law schools to stabilize the law. And I want to argue and argue in the book that actually the purpose of legal history is not to stabilize the law, but to question it and to subvert it. And that's why the book is called Subversive Legal History. It's the idea that legal history actually questions the law, and it shows that everything that law students are taught is a construct, is contingent, and also can be subject to change, because things were done differently once and different options were looked at once before. And so what legal history does is it shows law students that there are different ways of thinking and different ways of doing. It's effectively a form of comparative law, but comparative in the sense of looking over time rather than looking across place. And so this concept of subversive legal history, what I'm going to be talking about today, which I talk about in more detail in the book, is about saying that actually, look, legal history isn't just desirable, it's necessary. It's something that should be at the beating heart of the law curriculum. And it's something which all law students should be doing. And it should be part of the toolkit in terms of understanding and in terms of critiquing law. Because, you know, over the last 30, 40 years, there's been this move towards interdisciplinarity and this move towards, you know, not just studying legal doctrine, although that's terribly important, but also putting that in context. And, you know, there's been the rise of socio-legal studies and all this kind of thing. And what I'm arguing in the book is that history is a vital bedfellow for law, and that actually you can only understand law properly if you understand it historically. So that's the basic outline of where we're going. But let's look in a bit more detail at the inaugural lectures, and in particular, Maitland's inaugural lectures. So these arguments are developed in the book. So a quick plug for the book is called Subversive Legal History, and it's published by Routledge, and is available now at more good bookshops and probably a couple of charity shops as well. So anyway, the basic problem is that summarized by Simons in this quote here, that there is a concern that legal history as a discipline is not at the forefront of what law schools do. I think he overstates it here by saying that it's comatose, but nonetheless, there is an issue that historical approaches to law are not as frequently examined compared to other process of law, and definitely in comparison to the study of doctrine. So let's look at these inaugural lectures, and let's go back, because obviously as a talk in Cambridge we have to go back to Maitland. And we're going back to his inaugural lecture entitled Why the History of English Law Has Not Been Written. And that was a self-confessed long and dismal discourse. But his basic concern was exactly the same concern as mine this evening. Why is legal history not flourishing quite as it ought to flourish? So that's not saying that it's not flourishing at all. I must stress that point. But, you know, what I'm arguing here is that legal history should be flourishing even more than it already is. And Maitland's argument was that legal history was not being constrained, and he was talking about research into legal history, was not being constrained by any lack of evidence. Rather, as he put it, it's the limits of our leisure, our strength, our studiousness, and our curiosity. And Maitland, in his inaugural lecture, as you're probably all aware, made this distinction between legal and historical approaches to English law. And he's talked about the two different logics. The logic of authority, that's, you know, lawyers are looking for authority and the more recent the better, whereas historians are looking for evidence and the older the better. And Maitland did talk a little bit about law teaching in that inaugural lecture. He pointed out that studying law with purely practical intentions would not result in appreciation of history, because what is required of a practicing lawyer is not, save in the rarest of cases, a knowledge of medieval law, for instance, but rather a knowledge of medieval law as interpreted by modern courts to suit modern facts. What other scholars have called a presentist approach, whereby you're only interested in the past to the extent that it sheds light on the present. And, you know, we spend so much time talking about what the purpose of an undergraduate law degree is, and obviously that purpose differs from institution to institution. But there's an awful lot of talk, particularly at the moment, given developments in relation to the solicitor's qualifying exam and that kind of thing, about the need to teach law students to think like lawyers, which is quite odd because, you know, in other disciplines they're taught to think like academics, but in law we want them to think like practicing lawyers, and that means that on the surface that means that there's no real place for history other than in this slightly perverted sense of history only being relevant insofar as it sheds light on the present law. So Maitland said, although it would be an exaggeration to say that the study of modern law and the study of legal history had nothing to do with each other, it was true to be both an excellent lawyer and to know little of the remoter parts of his history. And indeed, in the centuries that have gone on, that's even more true now, in that, you know, whereas, you know, when Maitland was teaching, you did need to know the details of the medieval writ system in order to be a good practicing lawyer. Our students today, do they ever actually get told about that unless they're studying legal history in some respect? And as wary as I am, particularly in the current context of this talk, to criticize Maitland, this is the argument that I'm going to be going against this evening, because Maitland was of the view, at least in his inaugural lecture, that the object of a law school was to teach law, and this was not quite the same thing as teaching the history of the law. And he came to the reluctant conclusion that in the ordinary teaching of law school, there is little room for history, hardly any for remote history. And Maitland has been proved right on this. If you sort of look at, you know, textbooks, If you look at syllabuses, if you look at the content of the SQE, there is very little room for history there. But I'm going to be arguing that not only is that a shame, but that also means that we are producing students as a result who are less qualified and less able to cope with the world of practice if they go into the world of practice. Because what I'm going to be arguing is that history is needed, not just for its own sake, but because that stimulates the critical thought and the critical judgment and the subversive thought and the subversive judgment that lawyers need. So legal history isn't academic, which is one of my sort of, one of the things that annoys me is that, you know, when sort of, many things annoy me these days. I'm sort of going more and more into middle age and morphing into a grumpy old man. But one of the things that irritates me is when sort of, you know, legal history is seen as this sort of academic subject, an academic module choice. And it's not. It's not academic. It's as practical as they come. It's about looking at legal doctrine, looking at the stuff which people would deal with in practice, but in a different way. And even if the content is not going to be relevant for practice, the method surely is. But Maitland's argument is that in the law school there's little room for history, and he asserted that we should not wish to see a professor of law break in and enter in the clothes of a professor of history. Well, again, this is where I depart ways with Maitland, because I think that we should do precisely that, whilst at the same time, of course, being very, very aware that it's a two-way process of learning between those who are experts in law and those who are experts in history, including those who are experts in current law and legal doctrine. So I am daring this evening in Cambridge to criticise Maitland. But Maitland's conclusion was reached, of course, at a time when legal education in the universities was at its infancy. And the kind of approach which Maitland was talking about, of a legal practitioner approach to legal history, which starts with the current law and works backwards, has been criticised as being dangerous. So there are obviously criticisms made of presentist, as it might be called, approaches to legal history. Plus, most importantly, I'm not really arguing with Maitland because he changed his mind. The answer is to do what Maitland did rather than what he said that he did. And as Pluckner has pointed out in early English legal literature, the inaugural lecture reflects Maitland's then undeveloped and imperfect view of the place of legal history, and his later career must be read as the gradual abandonment of the propositions laid down in 1888. So in many ways, what I'm arguing for is actually what Maitland did. And if there is a quote which is at the heart of subversive legal history, and my argument, the need for legal history, it's this. This is a quote from Maitland in a letter to Dicey, so 1896, so that's a couple of years after the inaugural lecture, and it's probably one of the few places where Maitland ruminates about the purpose of legal history. And of course, it's notable that he's saying this to Dicey. And Maitland says this: "The only direct utility of legal history lies in the lesson that every generation has an enormous power of shaping its own law. I am sure that it would free them from superstitions and teach them that they have free hands." And basically, my book on subversive legal history is page after page after page elaborating this quote, because this is exactly what I mean by subversive legal history. because I think that legal history can free law students from the superstitions which they are otherwise indoctrinated into on law degrees. Because the study of legal doctrine very easily becomes a form of indoctrination, whereby law students are told to think like lawyers and are told that only certain questions they should be asking and only certain things are relevant. Tony Bradney, professor of law at Keele, emeritus professor of law now, I think, at Keele, wrote a brilliant paper in the Journal of Law and Society a couple of years ago, Law as a Parasitic Discipline. And in that paper, he said that law students are taught to forget who they are. And that's what happens on a law degree. The kind of questions they would otherwise come up with, the kind of questions which people who haven't got a law degree come up with, are discouraged. And instead, law students are encouraged to think within the box of legal doctrine and are taught really that legal change is possible, that legal change is conservative, and legal change will operate almost like pieces on a chessboard. They are never allowed to question whether they ought to be a chessboard or whether we ought to be playing another game entirely. So, in Subversive Legal History, I point out that actually, paradoxically, history is everywhere in legal education. Barely a lecture goes by, barely a couple of pages in a textbook goes by, barely a seminar or a tutorial goes by when you're not going through, and law students are not going through, a case law over time. But that's not really legal history, or it's not legal history operating well, because it's legal history operating in that presentist mode of just trying to understand the present. So paradoxically, although we feel as if we're constantly doing history, we're not understanding those cases in the context of their time. And so actually, paradoxically, history is everywhere, but also nowhere in legal education. And I make this point through what I like to call a novel analogy, because I quite like a pun. And it's a novel analogy because I compare the way in which law students study a particular module or a particular topic, be that land law, be that criminal law, be that constitutional law, as basically studying a chapter somewhere towards the end, they think, of a novel in isolation. So they study this particular chapter. They study the law as it is now, but they do not look at where it has previously been. And so they're like studying just one chapter in Bleak House or one chapter in Pride and Prejudice without an awareness of what has happened previously in terms of the plot. Now, this is not to say that legal change is linear. It is not to say that law students need to look at history in order to see a line of development which the current law is on and to see the direction of travel. That is clearly not the case. And indeed, the novel analogy respects that, because what sort of novel is utterly predictable is one just clear line of cause and effect. In a novel, things will take unexpected turns. It'll be 2 steps forward, 1 step back. That is equally true of the law. That is equally true of legal history. My point is that without understanding where the law has come from, studying the modern law of trust, studying the modern law of contract, is like picking some random chapter which you think is probably somewhere near the end of the book, but you don't quite know, and just reading that chapter in isolation. It doesn't make any sense. Yet, that is what we do. routinely in legal education. And a summary of what we do routinely in legal education is summed up by this quote from Lord Gough. I mean, when you step back and think about it, it's rather absurd, because basically what we're doing is we're training law students to be High Court or Court of Appeal judges. That's effectively what we're training them to do on the law degree, because what they will deal with in practice, you know, for the bulk of their career, particularly early days, are completely different from being able to understand, I don't know, for instance, the developing, the case law on how the word intention has developed over time in criminal law, or the rules in relation to offer and acceptance in contract law, which still kind of assumes we're in the 19th century and we post things to each other. So what my point here is that, yes, there's a number of really good reasons why we want law students to develop the skills summed up by Lord Gough, to be able to take cases and statutes on a topic, to be able to look at them, to build them up, and to work out what the law is. And then to look at what the law ought to be, perhaps, with looking at proposals of reform. So yeah, this is a valuable skill. But my word, if law students are only doing that, are we really preparing them for life in practice? And are we really preparing them for life outside the academy as well, in terms of being able to question the world around them? Yeah, because these skills are, you can get into a box and you can sort out the stuff that's in your box. Well, why have we got that box and not another box? Those questions are not questions which are developed in this mode of legal education. Now, of course, I'm talking in ideal types here. I'm talking in stereotypes. It's obviously the case that law degrees up and down the country do more than this. But this is the bread and butter. This is the norm. And what I'm arguing is that history provides a way of subverting that norm and a way of allowing law students to build up those important skills of the jurist, whilst also building up critical thinking skills, which are increasingly important. And the basic point I'm making here is that legal history stresses that the law is contingent rather than fixed. There's a fantastic quote here from Phillips, which says that legal history shows us that the law is not a set of abstract, ahistorical and universal principles. It does not exist in a vacuum. And that lesson is often lost if you've got a legal curriculum which is not historically informed. Because legal history allows us to see what we think of the law today and what we assume to always have been the case has in fact not always predominated. History shows that ways of thinking other than conventional wisdom are possible. A historical approach shows that every line we draw in the law today, every sacred cow, every distinction which we think is universal and which we treat as being cemented, doesn't have to be there. Because it shows that other ways of thinking were possible, because either they were done previously or they were contemplated previously. It shows that every distinction that law students are indoctrinated into. So, I mean, the classic example here is the distinction between contract and tort. You know, these are sort of now, you know, textbooks really perpetuate the idea that these two are two completely separate areas of law. They're different modules, etc., etc., etc. Yet a historical approach, of course, shows that that is complete nonsense, and shows that, you know, as people on this call will know all too well, that often significant developments in the law of obligations comes from, as has come from, borderline disputes between what we now call tort and what we now call contract. And indeed, as Rosemary Akamuti has pointed out, a historical approach can highlight the power struggles, the opposition to reform, and the agency of those campaigners who ultimately succeeded or not. And it can therefore correct the way that students are led to believe that the law has evolved through internal reform rather than the result of radical movements. Because the dominant narrative, which is implicit in much of legal education, is that of evolution, is that of the law slowly but surely correcting itself through the work largely of legal actors, through bodies such as the Law Commission, through Parliament, through judges, etc. Yet, a historical approach can look behind that and can show, as Akamuti points out in this quote, that legal change comes about because of social change, and comes about either through campaigns or through ignoring campaigns. And a historical approach highlights those power struggles and highlights those roads not taken. So history can make us question what we know by showing that the law is contingent, malleable, and capable of change. It questions the dividing lines that have been drawn around the law, what is included, what is excluded in textbooks and lectures, and the idea that law is autonomous and objective. As Horwitz puts it, a historical approach reveals that principles of mainstream scholars are historically contingent, and this unsettles the unorthodox approach, because that orthodox approach regards history as subversive because it exposes the rationalizing enterprise, and that's exactly what subversive legal history is all about. And I'll be honest with you, I mean, I didn't set out to write a book on subversive legal history. That was never the purpose. It was meant to be the opening chapter of something else, which I'm still currently working on. But these ideas about the need for legal history and the ideas that legal history subverted law rather than stabilized law grew and grew and grew in that chapter and in other works. And when I started talking to people about this, I could see that, particularly amongst those who were not legal historians, a light was going on. People were nodding. And that rarely happens when I talk. Usually they sort of shake their head or nod off. So I felt there was a message here that needed to be made, particularly, as I say, not in terms of preaching to the choir, but in terms of talking to people who see legal history as a specialism and see legal history as being something that they rarely, if ever, come across. And this idea that legal history is subversive is not particularly new. It's also articulated in David Sugarman's work. He, in his excellent piece on Writing Law and Society History, said that legal history is to take on the mantle of an all-pervasive subversive, illuminating the connections between legal, socio-legal, and political change. And that again is the stimulus of the book, and the stimulus of making these arguments in a work which is deliberately not solely pitched at legal historians. And it's all about this quote. It's all about this quote from Maitland, because I think legal history is all about freeing people, freeing law students from the superstitions, and from what they are otherwise taught and indoctrinated into, if I could put it in that slightly more extreme way, as part of their law degree. I should say, before I go any further, that I still think, despite everything I'm saying this evening, that a law degree is an absolutely fantastic qualification, because I'm aware this is being recorded. And I can think of no other subject which equips students to focus on the minutiae and the bigger picture at once. But what I'm saying is that a law degree could be even better if it was historically informed. So I want to develop my theme a little and talk about some of the other arguments that I put forward in legal history. And I was talking a minute ago about the fact that a lot of these arguments which I've been making this evening, which are made in the book, are particularly aimed at those who don't see themselves as legal historians. And this includes an awful lot of people, an awful lot of legal academics who are doing work on history. We had a seminar a good few years ago in Cardiff, which felt a little bit like an I'm Spartacus moment on the film Spartacus, because sort of we went around the table and people were saying what work they were doing. And they were often saying, I'm looking into 19th century copyright laws, or I'm looking into 20th century divorce cases, etc., etc., etc. And then they would almost immediately say, but I'm not a legal historian. And I sat there going, but you are. You are a legal historian if you're looking at the law historically. And I think that this is a major, major problem, that we've got lots of history going on in terms of law school research up and down the country. But a lot of these people would not call themselves legal historians. And why is that? Well, that is because there is this division and this distinction which is often made between the old and the new legal history, the internal and the external, the doctrinal and the socio-legal. Or as Norman Doe and I once referred to, I'm aware Norman's on the call this evening, the textual and the contextual legal history. And so there's a significant number of people who are doing what might be styled the external legal history, or are writing socio-legal histories rather than looking at the history of legal doctrine. And they would call themselves socio-legal scholars, but they would not call themselves legal historians. And so in subversive legal history, one of the arguments I put forward is that legal history definitely includes both of these camps. It definitely includes all of these people. And moreover, the argument I'm making is this distinction between the old and the new is actually unhelpful, because these are not two opposite camps. These are not two polar camps. These are not even two separate camps. These are two overlapping and complementary camps. And so in subversive legal history, I call these two approaches intellectual legal history and social legal history. Or to be more precise, legal history that borrows from and utilizes intellectual history, and legal history which is more in the social history tradition. And I use that language deliberately to show that this work is using ideas from history as a discipline, but also that these are not separate camps. These are not separate approaches. They are simply different ways of looking at things which are relevant, because which are chosen rather because of a particular research question. And again, this isn't a particularly novel idea, because I took inspiration here from a statement from Sir John Baker in his brilliant piece on criminal course and procedure. And he's got this throwaway line in this particular chapter where he says law flits uncomfortably between intellectual and social history. And with a lot of John Baker's work, every single sentence is a gem, and every single sentence is incredibly useful. And this sentence, which, you know, is just sort of there in this particular piece, is the inspiration for this reconceptualization of the two types of legal history. So what are my principles of subversive legal history? So my principle one, there's two basic principles of subversive legal history according to the book. Principle one is that subversive legal history recognizes the value and complementary nature of different forms of legal history. We shouldn't ignore the divisions, but we need to build upon them. And we need to recognize that when we're doing history as a whole, not individual scholars, but as a field as a whole, legal history has both an intellectual history dimension and a social history dimension. And my second principle of subversive legal history is that legal history, needs to be critical and transformative. And here I draw upon and develop the critical legal history approach of David Sugarman in the UK, but also numerous scholars in the United States. And critical legal history is often regarded as being in that second camp, as a type of external legal history. And there's often references to it being in opposition to internal doctrinal studies. But in subversive legal history, I argue that is misguided, and that they need each other, and that all legal history should be critical. So what do I mean by that? Well, again, I'm sort of talking to an audience who probably knows an awful lot about critical legal history, but critical legal history is about questioning conventional understandings of law, and in particular that linear idea of law as a system which is constantly being improved and evolving over time. And critical legal history, and I really like this quote from Robert Gordon, critical legal history is any approach which produces disturbances in the field, but inverts or scrambles familiar narratives. So critical legal history, or critical history, is about shaking up the snow globe in a way, and is about looking at the picture from a different angle. And that can be a different angle by looking at it, by emphasizing class differences. That can be a different angle from moving things from the margins, like gender, which are often on the margins, and moving that to the mainstream, or race, in terms of critical race theory, etc. And so critical legal history is about looking at the familiar in a defamiliar way. And it's about disturbing, I would say subverting our picture, our framework, our lens. And as I've been saying, you know, this can be feminist, this can be an exercise in decolonizing the law curriculum and decolonizing legal history. But the word critical here is a little bit problematic, because it is linked to the critical legal studies movements of the late 20th century. And of course, that movement is no longer as dominant as it once was. So are we simply reheating intellectual battles which have previously occurred? Is a criticism which can be labelled here, can be made here. And also, of course, the word critical now is often used so much that it becomes meaningless. And critical is often used, you know, in terms of critically assessing simply means assessing properly. So I do think the word critical is problematic, which is why the book is not called Critical Legal History. It's called Subversive Legal History. But how then do we subvert? Well, the book looks in more detail at the work of Robert Gordon, and in particular plays around with this quote from his seminal piece on critical legal histories. And that piece sought to describe the distinctive mode of legal history being written by critical legal scholars, but also, and this is the bit I found particularly interesting, had the broader aim, and I quote, of trying to tease out and make explicit a set of background assumptions, here called evolutionary functionalism, about the course of Western history that American legal scholars tended to take for granted and to challenge those assumptions. And I think that's the role of legal history. The role of legal history is to challenge the assumptions which are otherwise there about the past and its relationship with the present and its relationship with the future. So I think, and the book argues in some detail, that Robert Gordon's idea of evolutionary functionalism is the very thing that we ought to be questioning as legal historians, and which legal history can question. Because evolutionary functionalism is the type of history which is everywhere in law schools and in legal education. That idea of over time, things get better and better, and the law is effectively functional. The law is the default state is a state of equilibrium. So, what I'm arguing in Subversive Legal History is I'm building on Gordon's argument and arguing that legal history can be used to highlight and to question and to supersede the dominant but often implicit ideas of evolutionary functionalism, which are everywhere in legal education. And as Gordon points out in this quote from his brilliant book, Tame in the Past, which is a book of, as you'll be aware of his essays, and is a fantastic read. Evolutionary functionalist histories all have in common the kind of processes of social evolution that he's describing on that slide. The shift from ascribed to achieved status, the triumph of the middle class, the extension of the market. These narratives are entrenched. They're not good legal history, though. They're not legal history at all, because they're entrenched by people and by curriculums and by textbooks which aren't doing legal history. What they're doing is they're referring to background assumptions of evolutionary functionalism. So in the book, in Subversive Legal History, I argue that rather than being archaic, legal history should actually be anarchic. Because comparison with the past questions how the law and legal institutions are not fixed, but are constructed, that every line drawn in the law and everything the law holds as sacred is arbitrary, and how the environment into which law students are socialized into is a historical construct. And what I'm arguing is that a subversive approach is needed to highlight, question, deconstruct, and reconstruct the authored nature of the law, revealing that legal change on a larger scale is possible. So we need to move beyond legal evolutionary functionalism. We need to recognize how dominant those ideas are, and then we need to question them and show that they are simplifications, and to show that they are inaccurate by doing legal history and by encouraging law students to look at the messy reality of our history. So in the book, and this is where I get into a little bit of higher concept theory. So if this is not your kind of thing, I do apologize. You're not going to enjoy the next 5 minutes. In the book, what I argue is we need to move away from the idea that the default of the law is evolutionary functionalism to the idea that the default is what I call entropic complexity. Now, entropy is a scientific idea which is about if you leave matter, it gets more and more complicated over time and more chaotic over time. And so the concept of entropy denotes the gradual decline into disorder. And in the book, I look at legal works and sociological works on entropy. I merge them and develop them with works on chaos theory, with stress that a chaotic state is normal, and chaos is different from complete anarchy. But chaos theory entails the acceptance that things will get more and more disorderly over time. Things will get more and more complex over time. And applied to law, chaos theory tells us that the contradictions and disorder in our legal system are the norm. And law is unpredictable. Law is erratic. And so textbook writers who are trying to show that the law is rational and are trying to show that there is a neat, linear line of legal change are papering over the norm, are papering over the entropy. And legal history can show students the reality, the cracks behind the wallpaper, so to speak. And in addition to entropy theory and in addition to chaos theory, there's also complexity theory itself, which again I talk about in the book, and that shows the level of travel. And what's interesting about complexity theory is that it says that a complex system exists where there is what's known as emergence. And what is meant by emergence is the idea that the whole is now greater than the sum of its parts. So a system has emergence where it basically has a life of its own, basically has a form of autonomy, not complete autonomy, obviously. So law definitely is a complex system. We talk about the legal system. You could say that it has a level of autonomy. You could, if you really want to go for it, say that it is a form of artificial intelligence. But what I'm saying here is that a legal history approach allows us to question the dominant narrative, the implicit, taken for granted dominant narrative of evolutionary functionalism. And what I suggest putting in its place is entropic complexity. And there's more here about, on this slide, about the fact that a complex system hides its own chaos behind an image of stability. And that's exactly what the jurist is doing. If you go back to that quote from Gough, Lord Gough earlier, this is exactly what our legal textbooks are doing. This is exactly what an awful lot of our lectures are doing. We're taking something which is chaotic and unpredictable, and we're trying to present it as being stable. We're trying to present it as being rational, as there being a point, as there being a structure. And indeed, this is how a complex system uses history. It uses history to stabilize what is naturally chaotic, what is naturally unpredictable. But what I'm arguing is that history shouldn't be used to help cover this up, but actually should be used to unveil it, should be used to show the chaos within. And this is vital for law students, because this then will allow them to develop critical thinking critical thinking skills. This will allow them to question whether the status quo is working. This will allow them to look at other options. So in the book, I put forward 7 characteristics of entropic complexity, and 7 characteristics really of what could be achieved by this approach, this subversive approach. And this explains in 7 steps what an entropic complexity approach to law does. So first of all, it rejects the evolutionary aspect of evolutionary functionalism. It rejects the idea that law is linear, legal change is linear or progressive. This means that rather than focusing on origins or endpoints, we need to look at the intellectual history of the ebb and flow of legal ideas. 2, it rejects the functionalist aspect of evolutionary functionalism. The idea of functionalism, the sociological idea of functionalism, found, of course, in works of Durkheim, Talcott Parsons, etc. The default of law is not equilibrium. Law is a complex system, and the natural result is entropy, it's chaos, it's unpredictability. And so uncertainty, nuance, and flexibility are actually the default in law, rather than something to be ironed out. 3, entropic complexity liberates the way in which we understand and analyse law. It opens up significantly the prospects of legal change on a much wider level. And it underscores the limits of law and shows that legal change is not limited to what can happen on a chessboard. And it's not about providing a solution in the same way as solving a mathematical equation. How often is that what we ask students to do? In terms of, here's a legal problem. How often is that what we do in our doctrinal and indeed our socio-legal journal articles? It's, it's about talking about how to solve this particular problem. My 4th point, entropic complexity complicates but makes more important the role of the legal historian. Our role now is to explore the multiple causes and multiple consequences of legal phenomena, noting that this will be interpenetrated by non-legal phenomena, noting that prediction is difficult but not impossible. And 5th, it stresses the need to examine individuals and systems. So an entropic complexity approach really hammers home the need to look at how legal systems develop, but also to look at the roles individuals play within them. And 6, it emphasizes the dynamic interconnectedness of systems and shows that you cannot distinguish between the legal and the non-legal. And indeed, that firm line we often draw between the legal and the non-legal is something which comes about as a result of evolutionary functionalism. The 7th point is that entropic complexity requires a subversive approach to the analysis of law, recognizing that the artificial intelligence of law is constructed and shaped by particular people with their own biases, assumptions, and values. An approach that focuses on entropic complexity emphasizes power relations. It emphasizes the biases found within the law. It focuses on the agency of people. It focuses on the agency of those who have been marginalized. And it's about questioning, deconstructing, and crucially reconstructing concepts, ideas, and boundaries, including those around areas of study. I've raced through those 7 ideas, and they're 7. There's quite a lot there. So how do we do this? Well, as with quite a lot of things I've talked about over the last hour or so, it's about going back to a quote from an eminent legal historian and taking inspiration from it. And again, it's going to a quote from Robert Gordon here, where he talks about the difference between what he calls the functionalist approach and the critical approach. And in particular, it's this bit of the quote in bold I want to briefly highlight as a way forward. Because he says, while the critic takes each event as situated not on a single development path, but on multiple trajectories of possibility, the functionalist, by comparison, looks at one particular path over time, looks at the evolution of one particular idea. Whereas a critical approach, according to Gordon, looks at each historical incident and looks at multiple trajectories which could have occurred, multiple possibilities. Now, from this in the book, I talk about counterfactual history and counterfactual legal history in particular. I'm not going to go through this in detail. There's whole another presentation on counterfactual legal history. I've got one on my YouTube channel if you are so if you want to see it. There's a chapter on it in the book on subversive legal history. But basically, by looking at different options and looking at the roads which were not taken, that can be used to question and to challenge the stories, the narratives, the explanations which are taken for granted and which have become foundational. And it can be used to question the assumptions that the current shape of the law was inevitable or is natural. And it provides a means of highlighting, questioning and superseding evolutionary functionalist assumptions. And it's fairly easily done. We can just ask, well, what if a case had been decided in another way? What if a statute or statutory provision had not been passed? Would the changes have happened anyway? Would there have been other vehicles for reform? Would things have gone in a different direction? And what was the role of people and factors outside the law? So I think there's a place for counterfactual history there to be used as part of our subversive legal history I've been talking about over the last hour or so. And if you please, I'm now coming to my conclusions on this. And what I've tried to do this evening is to sort of give you a pitch-stop tour of some of the ideas which are found in the book. And as I said at the start, you know, I chose the title really because this is the nearest I'm ever going to get to an inaugural lecture at Cambridge. But let's go back to those inaugural lectures. And we've talked quite a bit about Maitland's inaugural lecture, but let's talk about John Baker's inaugural lecture on why the history of English law has not been finished. Because in that lecture, or at least in the version in the Cambridge Law Journal, Sir John said that he'd heard it said, now this was 21 years ago, this was the year 2000, and he said he'd heard it said that with so many changes taking place in the law and in the legal world, legal history is becoming a less important branch of legal scholarship and less relevant to a student's need. And obviously the argument I've been trying to put forward this evening, preaching to the converted has to be said, is that legal history should be incredibly important as a method of legal scholarship and should be something which is at the beating heart of the legal curriculum. So my concerns in 2021, 2022 even, are the same concerns as Sir John raised in the year 2000. And instead he observed that then, and probably now, career prospects are instead seem to be advanced more by, how he put it, by flamboyant essays stating either the obvious or the absurd in fashionable jargon. Thank you very much for listening. I'm aware of what I've said today might well be both obvious and absurd, might indeed be flamboyant, and so might be the very thing that Sir John's lecture was criticising there. But what I've tried to point out today is that this approach to legal history, this subversive approach to legal history, is something that makes the study of legal history not simply desirable, but indispensable. And so I think we need to be bolder about what the purpose of legal history is and why it's important, and why all law students and all legal scholars should have a historical understanding of the law and to be comfortable with dealing with the law's history. Because legal history, I've been arguing, is not there to stabilize the law, but it's there to challenge it. It's not archaic, it's anarchic. And so the argument of subversive legal history is that legal history needs to be part of the toolkit for everyone who studies and researches law. And that is the main point. And as I say, I think it's a point which increasingly needs to be made given pressures on law schools and pressures on the legal curriculum at the moment. Right. Thank you very much indeed for listening. I'm now going to try and unshare the screen.
Thank you so much, Professor Sandberg, for an absolutely resounding defense of the need to incorporate legal history into the legal curriculum. I enjoyed that very much, and I'm sure our guests did as well. I will now open it up to questions. If you wouldn't mind putting up your little hand or just typing it into the chat, whatever is easiest, and I'll go in order where I can. To start out, Chris, I saw your hand first.
Well, thank you very much. That was really interesting. In Cambridge, I had a question about disciplinary boundaries. So in Cambridge, legal history is something that's practiced across at least 2 faculties, history and law. And I'm a historian and not at all trained in the law and never been inside worked inside a law school. I just wondered what the implications of what you're saying are for historians who do legal history. A lot of legal history is written by people who are trained and work as historians rather than from within law schools. And understandably, the focus of the whole argument was about the purpose of legal history, the activities of legal scholars, and the implications for students of law. But I was just wondering what this then means for those who are undertaking legal history outside of law schools and are not primarily interested in its implications for legal education, but who are studying law in historical context, legal institutions, something that is recognizably we would describe as legal history. Does this involve them reorientating their practice, or can they just carry on doing what they were doing anyway? So I'd be interested in your thoughts on that. Thanks.
That's a very, very good question. I mean, what I didn't say, but must have come across implicitly because you picked up on it, is that this is a book which is written very much for, and very much from the vantage point of law schools, rather than what's happening elsewhere. I mean, I think there's a sentence somewhere in the book, I think it's somewhere in the conclusion, which says there's a whole different book to be written on the same topic from the vantage point of historians. And I think my basic point here is that one of the things the book is saying is the need to learn from each other and the need not to erect boundaries which then become problematic. So I was definitely thinking of the kind of things he's just been talking about in the part of the book where I dismantle the internal-external distinction and stress that those people who see themselves as being interested in law and history, or as interested in the social history of the law, should be welcomed into the legal history fold. So yes, I don't think I would go any further than that. I mean, what's been incredibly gratifying is the fact that the book has been picked up by historians who are interested in law, and what a number of them have said to me is that it helps them to understand where lawyers and legal historians are coming from a little bit more in terms of our sort of perspective on it. But yeah, there's another study there, but also a huge amount that can be learned. And, you know, if the subversive approach can help to increase dialogue, to increase collaboration between disciplines, then that's fantastic. And, you know, that's kind of, that argument is there in subversive legal history. It's also my default argument, because after a while you kind of realize that you do make the same arguments time and time again, wearing different clothes, so to speak. And so, yeah, there's a line throughout all my work which basically says, you know, wouldn't it be nice if all these people talked to each other more? And I used to argue that in relation to lawyers and sociologists, in relation to religion, and this book now argues that in relation to historians and lawyers. And I think it's crucial that it's not just a conversation between legal historians and historians who are interested in law. The people who are really missing out are those people in law schools who don't think they're legal historians, but they are.
I've seen a few more hands up, but also one in the chat, so I'll go ahead and take care of that from Simon, whose microphone is not working. Many of us here agree with what you say, so a question about implementing this approach. Do you have suggestions for creating an appetite for history in the traditional curriculum, e.g. particularly effective ways of making students impatient with and hostile towards the presentist assumptions that drive so much law teaching, maybe a particularly pungent or telling example that incites students?
That also is a very, very good question. And I think my answer to it, which might be seen as a slight sort of not answer to that particular question, but I'll say it anyway, is that we need to normalize the idea that legal history is a method and is something which is open to all. And so I think that the answer is to try to smuggle in, if I could put it like that, as much history in as much of the legal curriculum as possible. And I do think that the, you know, at Cardiff, for instance, we've got a separate module on legal history, and that's great, and it's fantastic fun to teach. It's fantastic fun to see students who suddenly sit there and you say something and they suddenly understand what the purpose of land law is, or the purpose of tort is. But we should be doing that on the land law and on the tort modules, is my basic point. And in the book, I talk a little bit about the idea of vertical and horizontal legal areas. So sort of, you know, vertical legal area would be law of obligations, crime, etc. And I think that legal history is best understood and best taught as a vertical, as a horizontal thing, which goes across the whole curriculum. Now, how in practical terms you do that is a big question, and isn't something which I address in the book, but I'm sure is something which, because I think it's also very much sort of institution specific, and you know, and also is a part of my career I've moved on from. I've had a stint trying to run a law school, so I now do not try and advise others on how to do that.
Now, I have just seen a message in from Lauren stating she has a related question. Victoria, if you don't mind throwing her head in the queue, otherwise, I don't want to. I know you were there first, so.
That's all right.
Thank you very much. I was just going to say, I think Simon typed his message at the same time as I was putting my hand up, that I, and Russell knows this, have been trying to implement exactly this approach because I have the dubious pleasure of running both the land and trust modules at my institution. And what I have found so far, and it's obviously quite early days, is that I am giving them the history, and it's integrated throughout the modules. It's there every week. It's examinable content. It's in the exam, and the take-up is still virtually non-existent. Which is not to say I disagree with anything that you've said, or indeed the approach to doing it, but certainly based on the last year, and I've only been doing it for a year, I'm finding that even sort of giving it to them all the time and explaining to them why it's relevant and why it's interesting is not sticking, because in their minds they have that really powerful, well, this isn't going to help me be a solicitor or a barrister. So because Simon has said something very similar, my question has become a comment, irritatingly. But I just thought it'd be worth mentioning that I completely agree with your approach. And as you say, you're kind of preaching to the choir in this audience anyway. But insofar as that I've been trying to convince my undergraduates, I'm not having much success with it so far.
And I think a reason for that is what I call in the book the tyranny of the textbook tradition. I mean, the problem we've got in law, which our colleagues in other disciplines don't have, is that you turn around and there's a shelf full of books on equity. There's a shelf full of books on land, the contents of which are all the same. And as a result, law students can look at those books and go, that is what I'm expecting in land. That is what I'm expecting in equity. So I think there is a issue here in relation to materials. And I think also it might well be an issue in terms of having to explain why there's a rebellion against that tyranny. But also what I would also say is what is likely, I would imagine, is that those students who don't see the value of it now are likely to see the value of it later. And I think that's the other problem which we fall into in higher education generally at the moment, is that we're concerned with student satisfaction today rather than how it enriches them for tomorrow.
Now, I will say
I shouldn't get on that soapbox.
No, I will say they are enjoying the history content. It's just not translating into that kind of examinable engagement, which is half the battle anyway. But thank you, very interesting.
Victoria.
Hello. Well, I have an observation, and as a practitioner, I have to say that my legal history studies with John Baker and actually Toby Milsom have been some of the most valuable studies that I conducted. They're the only bits I remember from 27 years ago. And actually, on that note, I have a lovely and I think entirely supportive anecdote from Toby Milsom when I went to him and said, oh, should I do his legal history course for the LLM? He said to me characteristically modestly, there's no reason at all why you should study legal history, save, of course, that it stretches your legal imagination. And I have to say that it's entirely consistent with what you've said today, Russell. Really, that quote from Maitland to Dicey is saying something really pretty close to the reason for doing it is to stretch the imagination of law students and to equip them for really very fast changes sometimes in the law that they will face in practice. And I work in banking and financial services regulation. There is no textbook on the prudential regulation of banks. We're entirely reliant on our legal imagination to see what can be and imagine it. So thank you. I thought I'm entirely supportive of your talk and your theories, and I look forward to reading your book.
Very much. I think that says it all, really, in terms of, I think, if people are asked why legal history is important, they will come to similar conclusions as the conclusions I've come to this evening. I don't think I've said anything which is particularly sort of earth-shattering. The purpose of the book is that these things are not widely said because that question is not widely asked. And once it's said and once it's explained, then suddenly you get people come up to me and they say, oh, I now can see what the purpose of legal history is. I thought it was previously just studying out-of-date law. And yes, absolutely, it's that's a fantastic quote from Milson about the legal imagination. Yeah, absolutely.
Alec.
Great, thanks for that talk. That was really interesting. I remember picking up that subversive legal history and thinking, man, this would be great to have as a talk on the centre. And so it has been. I have a quick question. So, as I understand it, the sort of your approach is that the current education system in the law school is sort of a senseless mistake, and it doesn't serve anyone. It doesn't serve the profession. It doesn't really serve academics either. And you posit sort of that if that is the case, there must be significant independence from the profession for this to be possible, and the broader structural needs imposed on the legal education system. But I suppose what I'm thinking is, what if the two do in fact come apart? So what if more subversive thinking comes apart from the needs of legal education? So I guess you bring up this idea of stabilization. What if we actually need most lawyers to not be subversive? We need them to be indoctrinated for the law to be stable. And that if we encourage lots of lawyers to think highly critically and subversively, that would somehow destabilize the law. Obviously, it's an empirical matter, but I just wondered what your thoughts would be if it turned out to be true.
Yeah, that's a very good point as well. And I think sort of the problem with law schools, and this again is not an original observation at all, is that law schools are being pulled in two directions, between the university and the profession, in a way that other parts of the academy are not. And you know, in different places and different times, that tension is found in different ways. But yeah, I mean, one of the things that I really wanted to challenge myself with in relation to the book was to make the argument that legal history of the type I'm describing here is necessary for practitioners. And yeah, I can see your point in that, you know, when I go to a solicitor because I'm selling a house, I want him to be competent. I want him or her to be competent. And so I want an element of stability there. But I also want him or her to be able to look critically at documents in front of him, to question why things are being given to him or her in that way. And I do think that the kind of approach which I've outlined this evening would help with that, and also would help with him or her when they leave the office at 5:30 and turn on the news or turn on social media, whatever, and come across countless bits of fake news and constant bits of analysis which are questionable and deeply problematic. And I think that, you know, we are doing a disservice if we are not helping the next generation to be able to question things, particularly since this is a generation which has information at its fingertips in a way that is deeply, deeply problematic in terms of being, you know, taking things at face value. So yes, absolutely. I want my solicitor to be to know what he's doing, but also I want him to be a little bit critical. I want him to be able to think outside the box and to also think, well, you know, why aren't they divulging this bit of information? You know, is this person lying to me? Etc. 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 That's a very good question.
And then David, thank you for your patience. Oh, I'm afraid you might be muted, David. Still nothing. No. Would you like to type the question? Would that be easier? I can go ahead and ask one in the interim while you're typing it, if that's sure. So thank you so much for that, Russell. It's absolutely fantastic. A lot of the questions I had initially about kind of the practical applications of this to a legal curriculum have been answered. And I would be curious to hear your thoughts on how it would be incorporated into the American system. I would tend to, just in kind of face value, feel that the need for the kind of injection of legal history is even more important given the position it takes as a postgraduate degree. But I have a separate question kind of related to just training young attorneys on how to understand precedent and stare decisis and all of this. Does your theory on complexity have a different complexion in relation to common law systems as opposed to civil law systems, or would you see an application to it in practically training attorneys in how to understand, specifically in the common law system, how to use precedent or kind of the lineage of cases to apply their understanding of legal theories?
Yeah, that's an absolutely fascinating question. I mean, I think my points about the extent to which that bad form of history is endemic is particularly true of a common law tradition because of a common law tradition of precedent. I wouldn't know and wouldn't want to comment on the extent to which it's also true of civil law systems, although I would comment that when I've spoken to people about this, they've been utterly shocked by how legal history is not central in law schools in England and Wales, whereas tends to be more in continental, or at least some continental universities. And indeed, I think sort of Scotland does sort of lead the way a little bit here as well, in terms of Great Britain. So there may well be a common law, civil law influence in play, and I think that's something which is well worth looking into. And this book is deliberately about my experience, really, and my vantage point. But I'd hope that there are things which can be pulled from it in other contexts. And again, I don't know enough about the American legal education system to say anything remotely intelligent about it. But I'm going to have a go. But again, I think that there is a risk that if legal education becomes focused on learning a certain amount of legal knowledge, then that is quite a limited education. I should say I'm speaking, as I've spoken throughout this talk, in a purely personal capacity. I'm not representing my employer when I say this, but if you look at things like the SQE, the solicitor's exam, and the idea that you can assess legal skills through a multiple choice test, that instantly creates an idea that there's a right and a wrong answer, or right and a quite right answer, or whatever it is, which is completely counter to what I've been describing this evening. I think I didn't want to make those arguments in the book because I didn't want to particularly date the book. But one of the motives behind writing the book was that concern, that legal education might be, in some places and in some contexts, going down a road which treats it as if it's maths, as if it's science, which I strongly disagree with. But I shouldn't get my soapbox on that.
Well, thank you very much for that. I saw Emily's hand go up. David, do we have any luck with the microphone or the chat? I don't want to pass you up because I know you've been waiting patiently in line. But in the absence of any kind of way to get the question out thus far, and I do apologize for any technical difficulties, If it is possible to put the question in the chat, I would be more than happy to read it, but I understand it could be a bit difficult. But while in the interim, I will turn it over to Emily.
Okay. Cool. Hi. Thanks very much for that, Russell. That was great. I will defend the importance of legal history with everything that I have. But I am also aware that probably in a parallel universe, there is a legal theorist giving a very similar talk to a group of legal theorists. And maybe there is a comparative lawyer giving a similar talk to a group of comparative lawyers. And that there are probably people in all sorts of different disciplines within law who are pushing or would like more inclusion of the work that they do in the curriculum. So I suppose my question is actually, is kind of the inclusion of legal history just part of, as you say, what needs to be a broader toolkit for law students? And the issue is actually to do with the fact that an awful lot of modules that law students have are taught in a very homogenous way. Or is there something special about legal history in particular?
That's a very good question. I mean, I think it's very important to say that I'm not saying that legal history should be automatically included instead of any other approach. And, you know, in an ideal utopia world, we would be including a whole variety of different approaches to law. But part of the motive of the book was that when we talk about interdisciplinarity in law schools, we often mean by that social sciences. We mean socio-legal studies. We might mean law and literature, but we don't tend to mean history. So I think it's one of the reasons for inclusion of history is its historical neglect. The other reason for it, and I've been thinking about this recently because I'm currently working on an edited book which does exactly what you've just described in terms of let's introduce all the different disciplines and see how they could all interact with law. And so what is unique about legal history? Well, I think legal history, all of them are useful and all of them are potentially subversive in that they can all potentially reveal different ways of thinking which can challenge the orthodox viewpoint. I think what history can do better than the others is that it provides a real concrete evidence of that difference. And I mean, you know, this again is not an original point. There's a fantastic festschrift written for Roger Cottrell, and one of the essays in that looks at Roger Cottrell's work. And Roger Cottrell famously wrote an article on why legal ideas must be understood sociologically. And in that chapter, in the festschrift, there's an argument that actually a lot of the reasons that Cottrell gives for a sociological approach are actually reasons for a historical approach. So there's also an element here of misdiagnosis. But yeah, I mean, I think the main argument, there's bound to be others, but the main argument is that history gives an element of concreteness and lived examples. And that's particularly important, I think, in terms of inclusivity and in terms of looking at roads not taken and people not listened to. Because we can look at those views, you know, for instance, we can look at those views in literature, we can look, you know, we can look at those views in science fiction or whatever, but history gives us a real life laboratory rather than just, he says, an act of imagination. That's not to say they're not important, but yeah, I think that's what history gives in particular.
And then Sophie. Sorry, I don't mean to interrupt, Emily.
Sorry, can you hear me okay there?
Yes.
Yeah.
Yeah, so just want to say thank you so much, Professor Sandberg, for a really engaging talk. As somebody as well who kind of is involved in interdisciplinary studies and trying to promote it to students, I found it really useful to get feedback from the students when I was trying to incorporate, for example, law and visual culture or law and art into their study of jurisprudence. But I was just wondering, are you aware of any research on the impact of legal history on students? And I was just wondering, if you're not aware of any, would you be interested in perhaps a future project in this, just in order to try and really make the case for making this worthwhile and to understand the impacts of it on students, not only in terms of their career, but I suppose then in terms of that really valuable term that's come out in terms of their legal imagination?
Absolutely. I'm not aware of any study, and I would love to be involved in such a study. I've sort of spoken to graduates informally, graduates of our course at Cardiff, who have gone on to a variety of different careers. And one thing I asked a couple of them sort of this time last year, you know, has your legal history course been useful? And why? And they gave me some fascinating answers, which I think I've stuck up as a sort of a YouTube clip on my YouTube channel. I mean, I'll be honest with you, the purpose of that wasn't really academic inquiry. The purpose of that was to find a way of promoting the book. But nevertheless, it proved fascinating. And I mean, what you've hit on the nail on the head with is the key thing here, is that, you know, the way in which we should find out about this is to talk to students. And what we've been doing at Cardiff for the last couple of years now is spending a chunk of the legal history course talking about things I've been talking about this evening, and talking about different approaches to legal history. And, you know, the feedback on that has been very, very good, particularly the parts that are not taught by me, but taught by my colleague. But absolutely, I think, you know, there's a real value to talking to students, and a real value. I mean, I'd love to know what a law student makes of the book, because in many respects, the book is kind of about them. So that would be fascinating. Yes, please.
Then I will put out a last call for questions. I don't know, David, if this is we can continue to try it, or if it's just not going to work. But I'm still not getting any sound. I'm sorry. But perhaps if it doesn't work here, Russell might be wanting to take your question separately from the seminar. I feel terrible. It's a shame when when these things don't work. But no, still nothing. Okay. No, I can't. I'm not getting anything through, and I'm not seeing anything in the chat either. If anybody else has seen anything that I'm missing, please do correct me. Oh, wait, no, it's just come through. Perfect. Thank you for what was a veritable tour de force. I applaud your effort to highlight the importance of legal history and to build a firmer bridgehead between legal history and substantive legal studies. And I agree with much of his characterization of both the current position of legal history in England and Wales and the potential virtues of legal history. But I think your arguments would carry even greater weight if they are more nuanced. One, your portrayal of legal history today is overly negative. Legal history is flourishing as never before in terms of numbers of individuals doing it, students studying it, courses on it, publication outlets, national and international associations, conferences and seminars, and the range of subjects tackled and the approaches adopted. There's a little bit of tilting at a straw man here. Two, in your written work, you have argued that history must be seen as an integral methodology that is part of the law student's toolkit. This implies that there is one accepted history methodology out there that law students can and should adopt, whereas the methodology of history is not a unitary monolith, but rather a contested, diverse entity. And 3, while I share your enthusiasm for legal history's subversive potential, I'm nonetheless uncomfortable about privileging legal history as opposed to, say, gender in the law, legal sociology, philosophy, literature, anthropology, and so on. Aren't they potentially subversive too? What we need is either a 4-year law degree or a law's postgraduate degree, as in the US, neither of which is realistic. And speaking from the perspective of a JD, I can certainly understand that. Finally, I think your case for the subversive qualities of legal history, with its emphasis on the way it empowers individual agency, as elaborated in Maitland's celebrated exchange with Dicey, exaggerates individual agency and correspondingly de-emphasizes structure, power, gender, race, and domination as forces that also shape both legal history and human conduct. These are meant to be constructive criticisms and do not detract from the undoubted value of your book. I wish you every success in your admirable effort to champion subversive legal history.
Thank you very much indeed. They are fantastic points, and are fantastic points which I'm not going to do justice to in a couple of minutes. But yes, absolutely. To take them sort of one by one, the straw manning, yes, absolutely. Put my hands up on that. I mean, I hope the book is slightly more nuanced than the talk, but I'm trying to highlight that I'm talking about the default and the norm. And obviously, there's a significant amount of stuff which is brilliant and awesome and growing. And again, that was a stimulus for the book, was the amount of stuff which is going on, which isn't seen as part of the legal history canon, and or is by people who wouldn't call themselves legal historians. The sort of the I'm Spartacus event I mentioned earlier. And so, yes, absolutely. I think there's a real danger of straw manning. And I think there's a real danger that legal history does that itself by various different means, and one of which is by the fact that for some reason some people feel outside and excluded, and you know what I'm hoping the book could possibly do is to show that legal history is less scary than often assumed. But absolutely, you know, as I think I said at one point of the talk, I'm talking about a stereotyping. I'm deliberately stereotyping. There's an awful lot of really good stuff, and you're right, it's growing. But my concern there is, but it doesn't grow into a ghetto. But it doesn't grow into an inward-looking area, because I've seen that happen in because before I wrote this, I've written stuff, and I still write stuff on law and religion, and I spent 10 years arguing that law and religion should be a separate subdiscipline like family law, like sports law, and that proved to be a bit of a disaster, really, because it meant that people ended up just talking to each other and didn't have the wider conversations with, you know, experts in family law, experts in sports law, etc. So I think there is a danger that comes with the kind of institutional growth of an area of study. And one of the most fun chapters in the book to write was the chapter that looks at legal geography and how that's developed as a really interdisciplinary field. And the difference between legal geography and legal history is that legal geography hasn't been limited, hasn't been institutionalized. So I think that that's a risk here with sort of, as things grow, it's very tempting to then to create institutions around them, like book series, like specialist conferences, specialist associations. And although all these things are great and good, and I spend some time doing those things, they are also dangerous. The point on the idea that there would be one accepted historical method is a really, really useful one. I really, really hope that my talk of legal history as a method isn't taken, because it wasn't intended to be taken, as suggesting that there is one approach to history. And indeed, the distinction I make between intellectual and social types of legal history is designed to show the variety of historical approaches, and that is really just the tip of the iceberg. And like I said in relation to a previous question, I think there's a whole other study of what we can learn as lawyers from historians and from different historical methods, and you know, that really needs to be written, and you know, if this book can help aid those conversations, it will have done more than I could have possibly imagined for it, and that would be, you know, fantastic and gratifying. Yeah, the third point, the privileging of legal history over other disciplinary approaches. I mean, this comes back to what I said to Emily. Yes, I mean, I think what I'm arguing for is that legal history is the seat at the table rather than should be knocking other people away from the table. And I think the risk at the moment is that history doesn't have that seat at the table, because legal history isn't seen as one of those law and subjects. And that may well be, it might be an issue here in terms of name. I didn't want to get bogged down on that in the book, having spent, again, 10 years discussing the phrase law and religion in sort of the level of detail which bored almost everyone. And one reviewer described it as navel gazing. So I'm obsessed about definitions, but I'm trying to rein that in here. And yeah, absolutely. The fourth point on agency and structure, and yes, I mean, the point I'm making is that legal history shows you that you're free to shape the law, but also I think legal history really shows you the extent to which law is shaped by structural forces, is shaped by power, is shaped by things like gender, things like race. And you know, I'm not. He's no longer on the call, so I can embarrass him at this point. But Norman Doe, one of the most insightful things I heard Norman Doe say when I was an undergraduate and he was a lecturer was, and it was a throwaway comment. He said, "The thing with law is it's just politics written up," and it is exactly that. Law is politics written up, but the study of law as legal doctrine, as this sort of rarefied sacred text, which has, you know, particular canons on and particular modes of interpretation, hide that from law students. So yeah, that's a very, very good point. I think sort of, yeah, you know, Maitland and that quote is my way in. To sort of tell people that legal history is useful because it can empower them. But then, you know, it's also very important to follow that up with the way in which legal history can reveal those structures that are in place. And, you know, some of those structures will still be all pervasive and very difficult to get out of. But at least recognizing them is a vital first step. Although obviously insufficient. So yeah, they are brilliant points.
Well, I'll go ahead and put out a last call for questions, and thanks to all of our survivors who have made it through this entire very fascinating seminar and question and answer session. And if we have no more left, I'll go ahead and say thank you so much, Professor Sandberg, for an absolutely fantastic seminar. It was very enjoyable, very informative, and I look forward to picking up the book as well. So I'll give you, because people can't hear me, a round of applause, but a virtual one as well. So thanks very much. And this is our last seminar at the center for this Lent term. We'll be back in Easter term with some more fantastic seminars, and we hope to see all of you there. So thanks, Russell, and thank you to all of our attendees.
Thank you very much for having me. It's been a pleasure. And thanks for all the excellent questions as well. that's food for thought. Thanks very much.
Thank you.